Yesterday, the Manhattan U.S. attorney brought federal criminal charges against the Industrial Bank of Korea. And the Industrial Bank of Korea, or the IBK, agreed to pay $86 million, both to resolve those criminal charges and to enter into a consent order with the New York Department of Financial Services. So financial institutions are now wondering, what does this mean from them? And today I'm going to talk to you about what happened at the IBK and what are some lessons that financial institutions can draw from that. The IBK is a global financial institution. It has hundreds of different branches in a dozen different countries, and its overall asset size last year was $242 billion. Back in 1990, it opened a New York branch. Now, that New York branch last year had $180 million in assets. So if you're trying to do the math in your head, that's less than 0.1% of the assets of the IBK are in the New York branch. So the New York branch was opened back in 1990 in order to provide correspondent banking services for the IBK, and it also provides wire transfer services and conducts U.S. dollar clearing, primarily for IBK branches outside the United States. What happened at the IBK is that a group of individuals took Iranian funds that were then transferred into IBK accounts. Those accounts were then, the funds in the accounts were then transferred into US dollars. Then they moved through financial institutions here in the United States and were transferred out to financial institutions that had accounts associated with that same first group. And this violated what's known as IEPA, or the International Emergency Economic Powers Act, which prohibits financial institutions from providing services to Iran or to the Iranian government. Criminal charges against the IBK were brought by the U.S. Attorney's Office in Manhattan. In fact, the unit within that office where I used to work. And the charges that were brought were a felony charge of willfully failing to have an adequate anti-money laundering program in violation of the Bank Secrecy Act. Similarly, the consent order that the IBK entered into with the New York Department of Financial Services was also based on failing to comply with anti-money laundering laws. The key takeaways for financial institutions can be identified by carefully reviewing the charging instrument itself, because the U.S. Attorney's Office identified the specific violations within the client's program that led to the bringing of criminal charges in what might otherwise have been a civil resolution. So one of the issues that was focused on was the bank's reliance on manual processing. And this is something that we've seen elsewhere. And as I've pointed out in writing elsewhere, it's actually legal for a bank to rely on manual processing. In fact, when the Bank Secrecy Act first was put into effect, that was the most common way for financial institutions to review transactions. But over time, as automated review has grown more sophisticated, both regulators and now we've seen even criminal authorities have focused on the absence of an automated process when identifying violations of the Bank Secrecy Act. A second issue that's come up is the adequacy of staffing. And there was a couple ways this happened for this bank. One was that there was only a single compliance officer, and that compliance officer was well behind in reviewing the transactions, months behind. In fact, that officer was months behind on reviewing the very transactions that later were found to violate IEPA. And a second issue came up when a second person was brought on to assist with the review, and that was based on the limited English skills of that individual and the absence of compliance training. And we've seen this elsewhere, particularly in branches of foreign banks, where regulators here in the United States have said it's inappropriate to have compliance functions carried out by an individual that doesn't have compliance training, and in particular for foreign banks, when that individual doesn't have a good mastery of the English language, and therefore it wouldn't really be possible for that person to easily get up to speed on how U.S. compliance laws function. In addition, there were multiple requests that went up the chain by the compliance officer to get more resources, and those were denied. And then finally, even after the problem was identified, it took the bank 18 months in order to solve the problem of the automated review. And we've seen this elsewhere, and this may be an instance in which the criminal authorities don't appreciate how long it takes for a bank to update its internal systems. but it's something that they focus on, and it's therefore something that banks should be aware of. And because the stakes are so high, it's incredibly important for branches of foreign banks and other financial institutions in the U.S. to consult with counsel when they're resolving disputes over a BSA or anti-money laundering violation. So if you have any questions, don't hesitate to give me a call. I'd love to talk them through with you.